Good evening, everybody, and welcome to Virtual Shadowing. This is our, Rachel, 37th session, is that correct? And we're so glad to have you here. This has been a phenomenally successful program that we've been going now for not quite 10 months. And tonight we have a very special old man friend of mine, Mr. Jack Ayres, and we're having some audio issues, so you're going to be stuck listening to me primarily for the evening. This has been a terrific program. We now have almost 44,000 people that have clicked through on the website, over 36,000 people who have signed up in over 950 universities in 28 nations around the world. It's clearly evident that for people that are seeking healthcare professions in the future, that they're looking for time with folks who have a message to share. And tonight there is no better person to share a message than somebody who's my age, which means old, but who has been around for a long time dealing with the issues of legalities and medicine. But before we get started, Rachel, you want to give some introductory remarks?
Yes, if you have any questions regarding our program, feel free to reach out to us on Instagram at Virtual Shadowing or email us at virtualshadowing@gmail.com. As always, this session will be recorded and posted on our YouTube channel, Pre-Health Virtual Shadowing. These sessions are brought to you by our working group comprised of Reagan, Shayon, Taylor, Elena, myself, Rachel, Ani Ruth, Miriam, Rohit, and our four physicians, Dr. Fowler, Dr. Marchetti, Dr. Salazar, and Dr. Reno. Next slide. So if you want to see more from us, we have a couple of interesting sessions coming up. We have not one, but two physicians coming in for our specialty spotlight in cardiology. Afterwards, we will be talking about forensic medicine, and then afterwards, we will have a PA coming in for critical care and finance. If you're interested in seeing those.
Before we go to the next slide, Rachel, the specialty spotlight next week is going to be just terrific. We're presenting, one of the cardiologists who presenting is also closely affiliated with the admissions committee at the University of Texas Southwestern, Shauna Nesbitt. She is especially interested in the areas of diversity and medicine and is truly a star in these areas. So you really don't want to miss this one. And then on February 23rd, we have a wonderful meeting. Stacy Hale is coming. Stacy is half emergency physician and half toxicologist. She spends about half of her time traveling around the nation, testifying in cases where there have been forensic toxicology cases that have occurred. And it is straight out of forensic files. You really don't want to miss that talk. So you are really going to enjoy that. So we look forward to having you participate with us. Rachel?
If you have any questions for our physician providers or for Mr. Ayres, please put it in the chat. Our team and I are going to be working to organize the questions for our two designated Q&A sections, one in the middle and one at the very end. If you have any questions regarding the assessment, please wait until the very end. We will show the assessment information after the last Q&A. And as always, the session will be about an hour and a half to 2 hours.
So, ladies and gentlemen, I'm sorry for the audio issue. We've been working on this for the last hour without a lot of luck. And I want to introduce to you tonight someone who I trust my life to, someone who I've known for 30 years, and someone who I came to work side by side with here 20 years ago at the University of Texas Southwestern. This is Jack Ayres. Jack Ayres is many things. He is attorney, policeman, and paramedic. And Jack has been directly associated with the EMS system, the pre-hospital care system here in Dallas County for over 40 years. He has done more having to do with the care of life than anyone that I personally know. He was a communication specialist with the Richardson Police. He was sworn in as a licensed police officer. He graduated from the UT Health Science Center as an emergency paramedic. Look how long ago. That was the year I entered medical school. That was the year I started clinical practice, 1978. He then began teaching law for the University of Texas Southwestern. What is that, Jack? 43 years ago. And then became director of the Emergency Legal Assistance Program at Parkland, where This man, Jack Ayres, has been on call for our EMS system here for over 40 years, 24 hours a day, 7 days a week, available to our online medical control to give instructions for people who need help. We'll come back to that in just a moment. But he's done so many other things. He's been an advocate for the American Board of Trial Advocacy, a master police officer. He graduated from Baylor, where he got his Juris Doctor degree from Baylor. He started teaching advanced life support and medical jurisprudence at the University of Texas Southwestern all the way to the present. And Jack received a wonderful honor, the Jaworski Fellow, Distinguished Instructor in Trial Advocacy from the Baylor Law School in the year 2000, an honor that he's held all the way to the present. So Jack, what do you do?
Well, I do several things. I have an active law practice in Dallas. I do primarily complex civil trials and appeals. I also serve, as you know, Ray, as an expert witness and a consultant in EMS programs across the country, primarily in the context of litigation in which EMS providers or health providers have been sued. I teach, as you said, at the Baylor Law School from time to time and conduct trial advocacy seminars there. And I teach, as you know, our fellows at UT Southwestern in the Department of Emergency Medicine on the average of about 4 to 5 times a year. That's a quick spread.
So in the teaching of the fellows, what you're really involved with is teaching physicians how to respond to emergencies in the field from the legal aspects of that. Is that right?
Yes, that's right. And to teach them enough basic understanding of the law not to be intimidated by it, to make it work for them as opposed to against them.
All right, next slide. Here we go. So,
well, excuse me, Ray, go ahead.
No, I was going to say, so why did you choose law? I mean, you could have played football.
Well, I did play football. What happened was that in 1966, I was admitted to Baylor on an academic athletic scholarship, and I was hurt in my first year, basically, which ended an otherwise unimaginative college collegiate football career. And I was unable to continue that, so I was sort of looking for something to do. I was originally pre-med, and I had advanced placement on a good part of my program. But if you all probably don't know this, but at that time, in order to your primary concern was your draft status, because you had to maintain certain educational credentials to avoid being drafted. And in that time period, I was able to complete my undergraduate work, and I was admitted to a program that was then handled by our chief medical examiner in Dallas, Dr. Charles Petty, and was able to audit some courses in the medical school. I audited about 3 semesters, and then I was advised that I could not stay at Southwestern in that program without declaring to be a physician in the military. I hope I'm not going on too much about this, but so you understand, that meant that I would have given the military 6 years for every year of medical school and another 4 years for every year of postgraduate medical training, which meant I would have been about 46 when I got out of the Air Force.
So Jack, there are over 600 people listening to you right now. Many are they're in pre-med or pre-PA or pre-NP. So you thought you were going to go to medical school, but you changed your mind.
Yeah, it was an involuntary change on my part, because in order for me to stay with my draft status, I had to return to Baylor in residence. I could not be in residence at UT Southwestern. For those of you that don't know, obviously that's in Dallas. So I returned to Waco and entered the Air Force ROTC program, and ultimately completed there, being commissioned as a captain. So that was the reason that I got out of medicine and into law. It was involuntary. I thought at that time I wanted to be a thoracic surgeon.
But it's okay to change your mind, huh?
Well, particularly at that time, because in 1966 through 1969, 1970, Vietnam was really hot. And I think the highest mortality in the military at that time was the first lieutenant in Vietnam. So it was a different time and a different circumstance for sure, but it was not easy for us at that time.
So why did you choose to work with the medical field alongside it, as opposed to doing something, you could have go sued lawyers somewhere?
Part of my career was a homicide investigator. And Dr. Petty, who, as I mentioned, was our medical examiner, sort of became a mentor to me. I think he wanted me to be a forensic pathologist, to be honest with you. And because of my background in law enforcement, we developed a fast friendship, and I then began teaching medical jurisprudence with him in the medical school. And as a result of that program, I was then selected by the Dallas Fire Department, who was starting its EMS system, to start their program as well. So it was a kind of a tortuous road, but I was very, very fortunate to have very fine physicians who took an interest in me and made a lot of things possible for me, chief among them Dr. Petty.
So let's go to the next slide.
Yeah, what I was trying to say here is that for those of you, I'm sure all of you have been, to some degree, been to college for sure. What I'm going to do here is an abbreviated effort to create something like a survey course that you would take as a freshman or sophomore in college, simply to give you familiarization with some of the major areas of medical practice that will affect your ability to practice medicine. And the first one that I think would be good to discuss, if we can go to the next one, is license requirements. I'm having to do this on a sort of an abbreviated way because each jurisdiction is different. So for those of you in the States, you should understand that each state has its own state medical regulatory board. In Texas, we call it the Texas Medical Board. But that will be one licensing agency that you'll have to complete their required course of study. In addition, you will essentially have to acquire a license of some sort from the Department of Health and Human Services in order to be credentialed to provide Medicare or Medicaid treatment. Without that, you can't be a provider. And so therefore, you would have to complete those credentials as well. And then something that's not quite as well understood is that the DEA, the Drug Enforcement Administration, plays a major role in medical practice today, because they so intensely regulate the sale and dispensing of controlled substances. So you have to have a separate license and registration from the DEA. And Ray, you and I can talk later in the presentation about how that interface took place with a very fine doctor here in Dallas and nearly demolished his career.
Absolutely. Now, Jack, let me understand this. So you're saying that if I go to medical school, do a residency, and then I apply to the Texas Medical Board and get approved, you mean I can't go to Georgia and just set up practice of medicine? I have to apply to Georgia also?
That's exactly right. And there are some efforts now to complete what nurses have as a sort of a compact system where you can have interchangeable licenses, but very few states now permit that. Now, there's one exception. If you're in the military service or in the U.S. Public Health Service, you don't have to be regulated by a state agency, but you cannot practice outside of the federal system, either in a military hospital or in a U.S. Public Health Service hospital. Otherwise, you have to be licensed by the state in which you practice.
All right, so let me see if I understand this. So A is a state medical board, and they give you the license to practice. And then B is the Health and Human Services credentials, and that gives you the license that gives you the certificate to be able to bill Medicare for your services. Is that correct?
Yes, sir. That's
all right,
correct.
And then the DEA, the Drug Enforcement Administration, that is so that you can prescribe narcotics to patients who require them. So these are three separate things. And you're saying that really for a physician to be in practice, or a nursing practitioner or a PA, they have to have all three.
Yes, I would advise them to have all three because they would be hampered in their practice without them. And two other things that are important. Each one of those agencies, State Medical Board, HHS, and the DEA, have a whole set of administrative regulations that have to be complied with. So it's not as simple as just getting a license. There'll be a lot of what I think are fairly hyper-technical requirements at each one of those levels, which physicians have to be familiar with.
That's great. Well, we'll go to the next slide now.
The next thing I thought I would visit with you about is the process for credentialing. As many of you may know, in the recent past, we've developed a lot greater emphasis on credentialing healthcare providers at all levels. So we're not just talking about medical doctors here or doctors of osteopathy. We're talking about nurse practitioners, CRNAs, paramedics, and physician's assistants. Each one of those have to be separately credentialed. This can be impacted by state law. I use Texas as the default example because I'm familiar with it. In Texas, we have a statute that says that although a physician may have graduated from a school of osteopathic medicine, they can nonetheless refer to themselves as MD because of the prejudice that was originally associated with the designation of DO. That's an example of where there's a specific state law. Another thing that your audience should be familiar with is that once they get into practice, if they have any sort of hospital practice at all, they will have to comply with the medical staff organization and bylaws. Most medical staffs have a constitution that has to comply with the JCHO, the Joint Commission on Accreditation of Healthcare Organizations. And it will require and will state a number of requirements for members. One of the requirements has to do with due process rights. So if you get into a situation where you have a credentialing problem, or shall we say, for want of a better term, a disciplinary problem with the medical staff, that will be in the first instance controlled by the medical staff bylaws. In addition, most states now have mandatory due process rights for physicians whose practice or credentials are in jeopardy. And both state and federal law applies to that to make those protections pretty helpful to a physician. Now,
all right, this is a really busy slide. So you're saying that after I get my medical license in the state and I've gotten the Health and Human Services certificate and the Drug Enforcement Administration, that if I want to be at a hospital, I have to actually apply for a medical staff membership and to be credentialed at that hospital?
That's correct. And that's a very important distinction because mere membership on the medical staff does not credential you to practice. In most hospitals, you have to meet the requirements of that particular hospital. Some, for example, I'll give you an example, will require you to be supervised if you're a surgeon by an attending on the medical staff, at least for first few cases that you have. So they vary widely from medical staff to medical staff. Most doctors don't realize that the medical staff of the hospital is separate and apart from the hospital itself. It's an independently functioning organization that exists, in my opinion, for the protection of the patient, to be sure that only competent practitioners are permitted to practice and there's a vigorous oversight from a quality assurance standpoint. If that helps, Ray, does that help them understand, you think?
Yeah, it did. But now then in that last sentence of the first paragraph, you said that there are due process rights. Do you mean that if I get credentialed at a hospital and somebody on the medical staff just decides they don't like me, that they can't just jerk my hospital credentials, that I have rights?
That's right. In fact, we've had in the Texas area in the Fifth Circuit, which is our court of appeals for the federal system here, we've had a major case against a major hospital here in Dallas where that exact issue occurred. Frequently, members of the same department will be direct economic competitors. In other words, competing for the same patient base. And in one instance, it was alleged that a physician was denied certain privileges and so forth because he was a competitive threat to the people who were in charge of the department. And that lawsuit resulted in a huge verdict here in Dallas in federal court, which was reversed by the Fifth Circuit. But you're right. a doctor has due process rights, which at a basic level mean a right to notice of what you're charged with, a right to produce witnesses and evidence, and to cross-examine people who are testifying against you. So it's in that way something like a hearing in court.
So, but the flip side of that is, let's say that a physician working at a hospital has a temper tantrum and ends up throwing something, then that physician will have to defend himself or herself in front of the medical staff via some sort of due process. Is that correct?
Yes. And I wanted to comment on that. When you said it, it made me think of something I should have mentioned. In the past, in my genre, when I was in medical school for my brief tenure, doctors did things like that. They would scream at nurses. They would throw things if they got angry and all that. And all that is pretty much a ticket out of medicine now. If you engage in that sort of conduct, at the very least, you're going to find yourself being examined by a psychiatrist or psychologist at your expense, and you're going to be taught anger management. This idea that doctors can behave in that way is no longer accepted in any medical center that I'm aware of.
Well, even further than that, then if something like that happens at a hospital, is the hospital actually required to report that to the state licensing board about that physician's conduct?
That's a good question. In Texas, well, in the United States, we have a thing called a National Practitioners Data Bank. And what that does is it provides a national clearinghouse for information about disciplinary action of certain types that has been taken against physicians. And the reason for that statute, I testified in those hearings in Washington, was because we had a flood of physicians who would commit malpractice in one state and they would relocate to another state. In the relocated state, frequently when they would request information from the previous hospital, the other hospital would not provide it except to say that they were on the medical staff in good standing. So what happened was that these people would go from state to state, continuing to do the same thing over and over again. And the National Practitioners Data Bank requires reporting of that sort of information by the hospital and or the disciplinary agency, including, by the way, medical societies, Ray, like in Dallas County, we have the Dallas County Medical Society. If they make an adverse determination of a certain type and character, it has to be reported.
So if a physician gets sued for malpractice, say, does the lawsuit, whether or not he wins, get reported to the National Practitioner Data Bank?
Generally, the lawsuit doesn't have to be reported unless it's adverse to the doctor. They may now require supplemental information if you're sued. In other words, over a pendency of, say, a year or two, you may have to make a preliminary report that you've been involved in a lawsuit, but it generally does not affect your eligibility unless it's adverse to you, and then there may be additional requirements. And one other thing I forgot to mention, Ray, that's real important to doctors is you need to understand that if you have a problem with the Texas, let's use Texas as an example. If you have a problem with the Texas Medical Board, if you have a problem with Health and Human Services in terms of your competence or your ethics or practice, if you have a problem with the DEA, all of those things have to be cross-reported. You have to report that to the hospital medical staff where you practice. You have to report that to the state medical board in some cases, and frequently you have to report it inside the hospital as well. So these things are interlocking, and the reason I tell you that is because a violation of one of those things can affect your other eligibility as well.
So this wouldn't happen to anybody on this call, but let's say that somebody had a little too much to drink, they were a doctor, and they got pulled over and charged with a DUI. Could that affect their hospital privileges? Could that affect their licensure at the state level and so forth?
Yes, it can. I've represented many doctors in precisely that circumstance. We're going to talk later about the problem of alcoholism in medicine. And I think that, again, you can expect the first time that you have something like that to get some sort of correction of a non-punitive nature. Generally speaking, most agencies now try to encourage people to get treatment, and even in our case at Southwestern, we protect the privacy of the doctor and the treatment process. You know all about this, Ray, but your audience may not. So we try to encourage people to get treatment rather than to be punished. But at the same time, if you're a repeat offender, if you have multiple violations of that sort, and that shows up on your medical staff member, I think there are hospitals here locally and ones that I'm familiar with nationally that would probably suspend your privileges because you then become a threat to them from a liability standpoint.
So really, to leave this slide, Jack, the last comment is there really is a code of conduct that a medical provider has to take on. And that code of conduct has to be not only in medical performance, being civil to the other members of the medical staff, but also not to violate the law, including such things as substance abuse and getting in trouble. Otherwise, the whole house of cards may come tumbling down.
Right. That's right. And this may sound a little Pollyannish, and I have as you know, a very high opinion of the medical profession because the people I work with and practice with, I have the highest regard for them. But let me make a couple of comments that may help your audience understand this. I think that sometimes physicians are so busy with their technical training and mastering the degree of complexity that goes along with the medical education that they forget the fundamental nature of the relationship between a doctor and a patient. And there's another slide that will discuss this briefly, but basically it's what the law calls a fiduciary relationship. And that means that the doctor must act solely in the patient's best interest, not in his or her own best interest, but in the patient's best interest. And that they must observe high standards of conduct and ethics as a part of their duty to the patient. Look at it from the patient standpoint. And I think doctors sometimes miss this. The doctor, when the patient comes into the hospital, the patient's basically helpless. They have no familiarity with the technology. They have no familiarity with the subject matter or the competence of the doctors or the nurses or even the janitorial staff. They're completely at the mercy of the system. And so it's in recognition of that we say that relationship is fiduciary. So physicians need to bear in mind that it's not just technical competence. It requires honesty, integrity, fair dealing, and in my opinion, I teach my students, putting the patient first at every turn, never putting yourself in a position when you're in conflict with your patient.
That's wonderful, Jack. I'll give you your next slide now.
The next thing that is a popular problem today is the issue of patient capacity to consent. Oftentimes, doctors who are not familiar with the difference between the concepts will use words that really don't apply to patient ability to consent. For example, I have heard doctors say that a patient was insane. Well, that's a legal term, not a medical term. That's not something that doctors deal with in terms of insanity. That's a legal concept. But the basic issue is that patient capacity to consent may be controlled by state law. And by that, I mean that there are statutes that govern it. Again, I'll use Texas as an example. If you are a patient in a hospital or you're an incarcerated inmate in a jail or a prison, the definition of your capacity to consent in Texas is supplied by statute, which may seem sort of ridiculous because really doctors should be making those decisions, but the legislature has stepped in and set what those standards are. There's also another matter that needs to be, and this is a sort of a feed over into another slide that we have later. When I was in medical school, probably one of the books that most impressed me was a book called Diagnosis of Stupor and Coma by Doctors Posner and Plum. And I think it's in, I don't know what edition it is, but it's a tremendous textbook. And they were able to basically get people to understand that consciousness and capacity were not black and white concepts, they were gray. And that it existed in a continuum from somebody who was in a coma that had no response to the outside environment at all to somebody who was completely sapient. And to try to draw those lines thinking of consciousness and capacity in a continuum rather than as an absolute. I wanted to mention one other thing, Ray, about this. It's a little bit specialized, but one of the things that I advise my doctor clients, particularly in high-risk specialties, to do is to consider either having a witness for informed consent by the patient, or, for example, I have a few plastic surgeons, I actually have them do a videotape recording of the informed consent with the patient in the office before they're in the hospital. The reason for that is that 95% of complaints against plastic surgeons are related to alleged false promises or warranties that were made about how the thing would look when they finish. And it frequently in that situation can turn out to be the patient's word against the doctor. And doctors don't always make the best witnesses. So that's why I have suggested, and many of my clients do that. They videotape, it's confidential, but it's for the protection of both the patient and the doctor. Here's exactly what we can promise you we can do and what we can't promise you we can do. That's an example of what I'm talking about.
Well, so Jack, is there an error on the slide? You used the word capacity. I thought it was competency. Am I not determining at the bedside of a patient that they are competent to give consent? What's this capacity word?
Well, that's the to show my age even further, even for you, Fowler. That's what we used to call the $64,000 question. That would have been about 40 years ago, or 50 maybe. Basically, capacity and competency have many similarities. Capacity in the abstract means the ability to understand the nature and consequences of what a person's being told. I'm being very general here. Whereas competence actually means the ability to apply that capacity in a particular thought process. Most disorders, as you know, in this area may be cognitive or they may be affective. We're now starting to understand that emotional crisis for patients can be as disorienting and as adversely affecting capacity and competence as a cognitive problem can. A patient that's profoundly depressed, a patient that suffered the loss of a loved one, or in COVID right now is a good example, may not have the capacity to consent in the traditional sense of the term. And I've always thought that's a medical judgment. But you're exactly right. You put your finger on a hot button issue today, the difference between capacity and competence.
So competency is more of a legal term, whereas capacity in a way is something we use in medicine to try to determine if the patient understands what we're trying to say. Does that express it pretty well?
I think that's a real good shorthand. This is another feed over to another slide that we're going to see in a minute. A dear friend of mine and yours, the late Ron Anderson, who was the president of Parkland Hospital and a giant provider, a dear friend of mine and yours, used to say that in these matters, doctors should be on the side of the angels. And that is that you always resolve any issue of competency or capacity in favor of the patient. And that means in most cases, if you're not certain that the patient really understands what's going on and is compromised in some way, you act in your fiduciary capacity to protect the patient, whatever that means. And I encourage my students to do that, as you know.
All right. Well, I've given you your next slide here, Jack, on the types of consent. Now, can you explain this for us?
Yeah, we were trying to give you here some examples of different types of consent issues that can arise in different contexts. The first one on the slide that Rachel was kind enough, by the way, I thank you so much, Rachel, for doing that for me, that Rachel set forth was the concept of a living will. When I started practicing law, there was no such thing as a living will. There was no legally binding way that a person could demand that if they were suffering from a terminal disease, that they would not be given treatment that they didn't want or need. And in some tragic circumstances, people would run up, I'm sure all the physicians are familiar with this, would run up bills in the ICU of hundreds of thousands of dollars or even millions of dollars with no real expectation that they would ever have a sapient state. So many states enacted statutes, as Texas did, enabling people to execute living wills. And in that situation, as Rachel has been kind enough to describe it, albeit from a lay perspective, the person that's signing the living will recognizes that they are suffering from a terminal disease and they do not wish to be kept alive by artificial means, unless and to the extent that their pain may be met and they may be hydrated, and if nutrition is an issue, it's furnish that sort of thing. That's a living will. That's a type of consent, an end-of-life issue that arises in consent cases. The next one is a medical power of attorney. Many of you have probably heard of the concept of a power of attorney, so let me explain what that is. That's just a document in which a person authorizes another individual to act as his or her agent. And we call that person the agent in fact, to indicate that they're serving under a power of attorney. We found out that those powers of attorneys were not helpful in providing medical treatment or consent for medical treatment, because under the law, when the patient becomes incompetent or lacking capacity, whatever flavor you want to talk about, then in that instance, the power of the agent to act is terminated, which meant that when the patient most needed someone to consent for them, for example, in medical care situations, they couldn't do that with a power of attorney. So again, states such as Texas enacted statutes authorizing the medical power of attorney. And in this way, a person can, in advance of an illness, designate individuals to make medical decisions for them. I'll share a quick aside. I don't want to tell too many war stories here. We'll be here all night. But I had a very dear friend of mine who I practiced law with. He was in his early 50s, and he had signed a medical power of attorney giving me the ability to consent on his behalf if he became unable to do so. Notably, he did not give that power to his wife or to his children. And his reasoning was that they would be emotionally involved if something happened to him, and he knew that I would follow his wishes. Well, that sounded like a real easy thing for me to do, and so I agreed to do it. And sure enough, he had a massive brain bleed and was in the hospital. He had a heart attack. He had a heart rhythm, and he had some blood pressure from time to time, but he was basically in a vegetative state. And I had to act under that medical power of attorney to discontinue life support for him. So that's something that most people don't think of. And most people, when they execute these things, designate a family member. And in my experience, it's a crapshoot as to whether or not the family member will be able to act in accordance with the wishes of that person. You might want to consider having someone that's a little bit more distant emotionally and has the, what do you want to call it, the courage, I guess you might say, to tell the family that it's over.
You know, Jack, there's 600 kids out there. Kid is a compliment, by the way. You and I are old guys, and there's 600 folks out there listening to you right now. And all of you have families. Many have elderly family members. And it's so critical that as advanced illness occurs, that people have everything worked out. We have an organization in Texas that works on a thing called the Physician Orders for Life-Sustaining Treatment. We actually have a nonprofit foundation here so that people can be very specific about what they want, and they can write down what they want. And then, as you say, enumerate the people, select the people who are going to help them make their medical decisions when they cannot make their own. Go ahead, Jack.
I think that's wonderful, because it's a form of patient autonomy, and it's also as any physician with any experience knows, these situations are undeniably tragic. When you have a family sitting around an ICU for months with a patient that has no real chance of recovery, it's a terrible thing for the family. It's a terrible thing for all concerned, and COVID is a good example of what I'm talking about. The last type of consent that we wanted to give you an opportunity to consider is what is called surrogate consent. And surrogate comes from the Latin surgas, which means one for another. And by that, I mean, in Texas, for example, we have statutes that state when a person is in a hospital or is unable to consent to treatment, this is a list of people who can consent for them in order of preference. And for example, in Texas, again, it may be different in other states, the spouse is automatically a surrogate for the other spouse. And you will get a kick out of this, Ray. I teach my students in law school that the phrase blood is thicker than water was coined by undeserving relatives. So frequently you see people who are given statutory powers of consent who are not particularly interested in the patient's welfare, but they're interested in collecting under the will. So bear that in mind, and that's why it's better to have a medical power of attorney where you pick your own representatives as opposed to having the state pick them for you, which they do in these statutes.
That's great. I'll take you to the next slide now, Jack.
Oh, wait, before next slide, sorry, we have a couple of questions in the chat. I hope you don't mind me interrupting with them.
No.
So some of the students are confused on like what is the difference between a living will and a DNR. Mr. Ayres, can you clarify on that?
Sure. A living will is executed by the patient. It is a directive, and it's in Texas called a directive to physicians. The patient tells the doctor what modalities of treatment they want and what they don't want. A DNR order is a medical judgment that is made by the physician that may or may not be something that's by the patient. Most doctors will honor a patient's wish to continue treatment, but from a medical standpoint, the DNR order is an order by the physician not to resuscitate. Now, generally speaking, those will follow living wills or the physician's conference with the patient to determine what the patient's wishes are. One is a hospital administrative order, and one is a legally binding document.
Gotcha. And then, so if there is a DNR and a person, like say not the physician that was in charge of the DNR, resuscitates them without knowing, is there any sort of consequences? Is the person who resuscitates them liable?
There are cases on both sides of that question, law cases, where someone will execute a living will. The hospital is aware of it. Physician, typically a house officer. When I say that, I mean what we used to call residents. We don't have interns anymore. Everybody's a resident once they graduate from medical school. But they would come in, not be familiar with that, and resuscitate the patient, and then the patient runs up a several $100,000 bill, which was contrary to the patient's wishes. And there's been litigation about that. So I think that it's an important thing, and Dr. Fowler alluded to this. Good doctors deal with this on the front side so that you have hospital postings that there's a DNR order. When you tell me that a DNR order or that a living will was not executed, that tells me there's usually a failure in communication in the hospital, because the hospital staff should be familiar with that. And if they are not familiar with it, and they should be, then they may very well be held liable if they treat a patient. In a technical sense, this is pushing it a little bit. If the patient has specified consent in only a certain way and care is provided in another way, that could technically be a battery of the patient and could give rise to damages.
Gotcha. Thank you for clarifying on that.
Sure. And
That's
anybody, if you run into something that we're saying that doesn't seem to make a lot of sense to you, like the difference between capacity and competence, feel free to let us know and we'll talk to you about that. Ray, I'm ready to go to the next one if you want. Remember I told you about my friend Dr. Anderson saying be on the side of the angels? In a medical emergency, the doctor-patient relationship is at its finest, as far as I'm concerned. And basically, the general rule is that when a patient presents in a true medical emergency, the physician has consent to treat the patient, and the doctrine is called implied consent. Unless the doctor is aware that the patient does not want to be treated for some reason, which is very unusual, then the doctor is justified in treating in the absence of consent. And Dr. Anderson is the author of the famous statement, be on the side of angels, because I used to go in to brief him and the board on some of these cases. And so he would say something like this: well, Jack, what you're telling me is that if we treat the patient, we can be sued. And if we don't treat the patient, we can be sued. Is that what you're telling me? And I said, yes, sir. That's what I'm telling you. He said, then we'll be on the side of the angels. We'll try to save lives and alleviate suffering. And if somebody wants to sue us, then we'll say, we're glad you're alive to sue us. Great man, by the way. Dr. Fowler will vouch for that.
Ron was a terrific fellow. Ron was, for the listeners, Dr. Ron Anderson was a magnificent internal medicine specialist who grew up here, did his training here, and then came on to be the chief executive officer for Parkland Hospital, the busiest urban trauma center emergency department in the United States. And Jack and I, Jack knew him longer than I did, but truly he was a master and patient advocate first and foremost. Ready for the next slide, Jack?
Yes, and I wanted to say I actually met Ron Anderson when I was in training as a paramedic. He was still running the emergency department. That's how old I am, fella. Okay, so now we come to end of life issues, and some of this stuff are matters of opinion. So bear in mind, I'm not here to impart some sort of universal truth to you that only great minds can come up with. If what I tell you makes sense to you and helps you in your practice, and use it. If you think it's baloney, don't use it. That's up to you. That's not my judgment. That's your judgment. But I started off with something Dr. Petty, my friend, my mentor, the medical examiner, taught me. He said, a doctor who attempts to predict the length of a patient's life is engaging in a fool's game, because no doctor knows how long a patient is going to live. And depending on your religious affiliation, we think that might be subject to higher control, if you get my drift, as opposed to the doctor's choice. So when you're dealing with an end-of-life situation, this is primarily ethical considerations, but it's oddly enough led to litigation. Ask yourself some questions. This is something that you may want to think of, and Dr. Fowler can amplify this because I've heard him say the same thing to residents in my presence before. If the patient wants to know something about their prognosis in terms of longevity, they will ask you. If they don't ask you, don't assume they want to know. What you're actually doing is projecting your own wishes onto the patient when you do that. And I learned from Dr. Petty that you take away the patient's autonomy and privacy when you force them to consider information they don't want to consider. And that's their right. They don't have to consider that information if they don't want to. Now, that's not to say that you as a physician don't have a responsibility to be sure that they're aware of information like that, but be careful about how you go about it. Should you supply unwanted information? I had one of my students who ended up practicing and coming back to our faculty, who decided that every patient that was nearing the end of their life should be approached about donating their body to our anatomical bank for as a cadaver. I told him that probably wasn't the best way to make friends and influence people, to be talking to the family in advance of the patient's death about donating their bodies. I asked in the slide, are you asking ethical and questions that are related to the best interest of the patient as a fiduciary? Or are you projecting your own personal views as to treatment? You may think that the patient should be treated. You may think that the patient should not be treated. Really, that's utterly immaterial. The question is, what does the patient want? And some people find it very, very difficult to make that leap. There's always a tendency on the part of some doctors to think that they know best. And that's what we call in medical education the God complex. And most of those people, forgive the expression, end up with their heads in a bucket, because that'll follow over into situations that'll get them in trouble in the law. One of the things that I would suggest to anybody dealing with an end-of-life situation, of course, you want to check on the DNR status of the patient. You want to check, as Dr. Fowler said, with the methods of treatment that are agreed to by the patient. You want to check and see if the patient's executed a living will. Be familiar with that. Be sure it's in the chart. Many doctors don't realize that that's important, that they need to do that. They rely on the hospital to do it. It's like the little boys playing baseball. Everybody thinks the other guy's going to catch the fly ball, and it falls right between them. So that's your responsibility as a physician. And another thing that I suggest frequently when these things arise, the doctor will come to me and say, I'm just not sure this patient is with it. You know, sometimes they have what we used to call, in my ancient days of medicine, lucid intervals, where they have a good deal of lucidity and they understand what's going on. Other times they don't. How about getting a consult? I think they call them psychiatrists, right? How about having them look at the patient? Maybe they have a perspective on the patient. Maybe they have an understanding that you don't. It's possible that you don't know everything there is to know about medicine. Shock. So that's supposed to be a joke, folks.
Oh, I'm
okay,
sorry.
Right.
I'm laughing, Jack. Okay.
Yeah, I can hear you. The next one is reporting requirements, Ray. Just so you know, as a part of your education as a doctor, under local law, and this includes city and county law as well as state law, there are certain things that are required to be reported by physicians. Some of them are certain types of contagious diseases. For example, if you have a patient that comes into your office with COVID, you're required now by order of the governor to report that to the Texas Department of State Health Services. Another example is gunshot wounds. The patient comes into the ER with a gunshot wound, and a lot of them that do this will have all sorts of extravagant explanations for how they got shot, as opposed to being shot by the police officer when they were robbing a bank or having shot it out with some gang group or something of that sort. We let the police sort that out. So we report that to the police and let them do it. Another common problem reporting is to parents regarding a minor's condition. Whether or not a physician can or should report things about a minor's condition to a parent is a matter of law. For example, if, and at least in some states, as in Texas, if you are, for example, seeking information about certain subjects related to pregnancy and things of that sort, there may be restrictions on what the physician can tell the parents without the patient's consent. And a lot of times physicians sort of go on the idea that they should share everything with the patient's family. Just be aware that there may be legal impediments to you doing that. You may violate the patient's right to privacy. There's an insert in this slide that is near and dear to Dr. Fowler and I. I want to, with Ray's permission, tell you a little bit about a truly exceptional, wonderful man named Larry Miller. Larry Miller was an emergency physician who was in charge of the entire Baptist health system's emergency departments in all their hospitals in the San Antonio area in South Central Texas. Not only was he extremely successful as an emergency physician, he invented the EZ-IO, which probably has saved as many lives as anything that I know of in medicine in the recent past, and donated a substantial part of the profits that he got from that to charitable foundations to people who are underserved.
Jack, let me interrupt. For those listening, the EZ-IO, Larry Miller is a wonderful man, and he, as an emergency doc, he had seen, as Jack has seen, and many on here have seen, how many times you simply could not get an IV line into an intravenous line into a patient. Well, the technique of drilling into the bone marrow space in the shin bone, in the tibia, had been around since World War II, but there wasn't a ready available device. And so Larry, over about 10 years, invented one: sweat, bullets, bloody murder, and finally actually took it to market, formed a company and sold this thing. And it's called the EZ-IO. And it's been wildly successful. It's saved oodles of lives. Larry alone went to Haiti with a bunch of IV fluids and EZ-IO needles in the cholera outbreak after the hurricane, and was a hero resuscitating people who were victims of cholera. Go ahead, Jack.
So we have an expression in the law that you should memorize, and you probably heard it in other contexts: no good deed goes unpunished. Let me repeat that for the slow learners. No good deed goes unpunished. Larry Miller, God bless him, was also a man of deep faith. And he believed that his license to practice medicine was not a property right of his. He believed that somebody gave that to him to enable him to serve others. That's a kind of a charming expression. So he became concerned that in many of the areas of rural Texas around San Antonio, there were many EMS organizations that couldn't get medical directors because there weren't enough emergency physicians to serve as medical directors, and those that were able to serve were concerned about liability. So Larry took it on himself at his own expense to offer to be the medical director for several agencies of EMS organizations in the South Central Texas area. Notably, one was in the thriving metropolis of Blanco, Texas, which I think has a population daytime of less than 1,000. So it's not exactly an urban stronghold. this is a teaching point on something that I talked to you before we go any further, to tell you a little bit about DEA regulations. You see at the bottom of this slide about the strict DEA regulations on completions of Forms 222. You probably can't see this very well. This is part of the Code of Federal Regulations that deals with the DEA and its regulations, and it is 350 pages long. These regulations are 350 pages long. One of them concerns Form 222s, which are the forms that you will sign as a medical director if you're in an EMS context or if you're dispensing medication. And it has to be completed in a certain way. The back side of the form also has to be completed. Probably not one. What do you think, Ray? One doctor in 1,000 knows that?
Oh, maybe.
Yeah. So as soon as you don't do that and the DEA comes in and reviews your records, then that's a violation of the regulations, and that subjects you to a civil penalty. Now let's return to Larry Miller, our friend, this wonderful person, good deeds. So he was a cutting edge doctor, and he was one of the first people, and not in the country, but certainly one in that area, to recognize the value of fentanyl in EMS application. And particularly for rural providers, which, as Ray will tell you, have a lot of problems with long response times and long bone fractures, which are very painful, fentanyl was a perfect drug for them to give these patients and to relieve their pain and suffering. Of course, Larry benefited nothing from the administration of fentanyl. He was trying to help patients. The other thing that you need to know a little bit about Larry to set the stage for this is that when you're talking about Ray and I in Dallas come from a fire department-based EMS system primarily. There are civilian providers, but they're not as prominent. In many cases, that reverse is true. EMS is almost completely civilian and is run by civilian individuals. And so in this case, Larry Miller had a director of the EMS program in Blanco, Texas, who was a paramedic and who basically did everything from wash the ambulances to stock them, all the sort of things that you would do in a routine operation like that. Well, I'll cut to the chase. Larry he had an emergency surgery, and I can't remember. I think it was an appendectomy, but anyway, it was an emergency. And so he was 2 days late in doing an audit of the records of this EMS service because he was in the hospital. Some people might think that would be a decent excuse, right? I'll come back to that in a minute. So when he got out of the hospital, he went to Blanco and he started going through the records, and he was shocked to find that several hundred doses of fentanyl were not accounted for in the records. And originally, when he asked the director about what had happened, he professed to have no knowledge about it. He was very concerned that the records weren't right, and he assured him that it was a bookkeeping error of some sort. And then finally, after Larry continued to interrogate him, he finally admitted that he had given over 250 doses of fentanyl ostensibly to his wife for her migraine headaches. He then took another position, having originally said he knew nothing about it, then having said that he gave it to his wife for her migraine headaches. His next stop on the crazy train was that he thought that Dr. Miller had authorized him to give fentanyl for migraine headaches, because he had given them general instructions to monitor the patients for pain when they were treating them. So Dr. Miller was confronted with an issue that is of great concern to those of us in the EMS. It's called drug diversion, where controlled substances are administered in a manner that is contrary to the medical director's supervision and contrary to law in this case. Dr. Miller did what I think was an amazingly honorable thing to do. He immediately reported this to the Texas Medical Board. He immediately reported it to the State Department of Health Services. He reported it to the DEA that this had happened and made full disclosure to them of all the information that he had, and cooperated with them fully in their investigation. They, of course, fired the gentleman that was the EMS director, and I think he's now on a scholarship at one of our penal institutions in in Texas. A full scholarship, as I understand, for some time in the future. So you would think that what more could the man do than that? He certainly wasn't responsible for the drug diversion, didn't have any knowledge of it, wasn't in any way culpable in it, except that he'd been 2 days late in getting the information because he was in the hospital. The United States, well, first of all, let me mention what we did at the state level. The State Department of the Texas Department of Health, which I used to be on the Board of Health, it's now called the Texas Department of State Health Services. We changed the name every so often so that people have to hire us to explain what it means, right? It's really the same thing, it's just renamed. They suggested that Dr. Miller's license to practice medicine should be revoked. And they reported to the Texas Medical Board that he had been complicit in this effort, which was false. The person who made that report was ultimately fired by the health department, as she should have been. But the damage was done, so then the Texas Medical Board initiated a proceeding to revoke his license to practice medicine. To add impact to that and to supply the fact that you never want to fail to kick a good man when he's down, the DEA, through the Department of Justice, then brought a civil penalty action against Dr. Miller for $17 million in civil penalties. The irony was that Dr. Miller probably had the $17 million to pay. And
he did not at that time, because his company had not yet been the success. He was still in the middle of a development phase, so he didn't have $17 million. And now later, when the company got successful, he did quite well.
Yeah. So he went to an erstwhile physician he knew in Dallas by the name of Raymond Fowler, I believe it is. He is a Georgia peach, still speaks with red in his teeth from the iron content of the Georgian soil. I think that might be significant cognitively, but we'll come to that at a later time. And Fowler had the audacity to recommend a lawyer to go to bat for Dr. Miller. One of the greatest honors of my life was to represent him in federal court. And the government didn't do too well in their action against Dr. Miller. And he was ultimately exonerated. His license was restored, and some issued, at my request, letters of apology to him for what they put him through. But I tell you that story because I would hope that any one of you, if you were my student, would turn out to be as good a man and as good a doctor as Larry Miller was. And that's what happened to the very best doctor you could imagine in this situation.
They also
so if you think
a critical take-home point, though, is that the Drug Enforcement Administration is on a warpath about the controlling of narcotics, and whatever physician signs for those narcotics is absolutely responsible. In this case, a medic under Dr. Miller's license and without his knowledge stole these narcotics over about 15 months and lied about it, but the doctor ultimately was still responsible. So be careful out there.
The moral of the story is these reporting requirements actually have real world consequences. That's why God bless Rachel for putting that on this slide, because it gave me an opportunity to tell you about my friend Larry Miller and also about my friend Ray Fowler, who's a pretty good guy himself in the tight spot.
Okay, next slide. You ready?
Okay, next slide is first Q&A. I think that means question and answer, Ray, if you're slow on that.
Yeah. Rachel, take it away.
We have a lot of questions, and people are very interested about what you have to talk about. First, for reporting requirements, if someone that you have to report on is, part of undocumented, do you have to report it to the police?
Generally, I say that there are exceptions to every rule, but I'll give you the general rule. Generally, you are not obligated to report the immigration status of a patient in the absence of some other circumstances, such as a crime or something of that sort. You are generally not required to report that. And if there was a regulation that comes through the immigration services, through the Department of Justice, that policy will be changed by the Biden administration.
Gotcha. What about if someone's under the witness protection program? Do you have to report to anyone special?
Boy, it must be a slow news day. Somebody's watching old movies, I guess. The likelihood that you'll deal with a patient that's in the witness protection program would be commensurate with the likelihood that you would be trampled to death by an albino zebra at 12 midnight on leap year.
Wow.
If a person's in the protection program, they're not going to come to see you. They'll go to see the government's doctor because they are instructed not to have contact with civilian authorities.
Oh.
I know that from my law enforcement background. I had a couple of people that got scholarship to the witness protection program.
That's pretty cool to know. All right. So one student asks, what are your thoughts about the legalities around medical assistance in dying? How accessible is it to patients, and how are doctors supposed to offer it?
Okay, that's uniquely a matter of state law. To give you an example, Oregon pioneered in the issue which they refer to as physician-assisted suicide, and by that is meant that the patient has to meet certain statutory requirements in Oregon, and if they do, it involves a consultation with more than one doctor to confirm that the patient's condition is terminal and that they're not going to survive. Then the physician may dispense medication which will enable the patient to effectively take their own life. This does not include active efforts by the physician, such as the old, I don't know if you all are so young you may not even remember, there was a famous doctor named Jack Kevorkian. And Dr. Kevorkian had a machine that he had put together that would administer lethal doses of medication to patients, and he was prosecuted for that in the form of a homicide charge in one case that I remember. And that's not the situation in Oregon. It is perfectly legal for a physician who complies with the statute to give patients those medications. There was a little dispute early on in some, and I'm not trying to say this in a religious context, but in what I would call right to life circles, there were groups, religious groups particularly, that were strongly opposed to that, and that was basically overruled by the Oregon legislature. And other states are in that area. I don't know of any that is as prolific as Oregon, but that's the best answer I can give you. In most states, physicians are prohibited from doing anything that could knowingly allow the patient to take their own life.
Gotcha. A couple of our students are still a little bit confused about consent and like the different types of consent issues. So what if there are no wills or documents for how to determine a patient's life or like their treatment? Do the family members decide at that point? Does the physician?
Okay. In general, those things are controlled by state law. So every state will be different. Remember, I told you, if you're in Texas, for example, and you're a patient in a hospital, there's a list of surrogates that can consent on your behalf if you're unable to. Remember, we talked about that. The spouse is usually first, and then the parents, and then collateral kindred of various sorts. So the typical way that happens is that the doctor will consult with that surrogate. And we sometimes have problems getting in touch with them, communications problems. Usually you can get social work involved in that if you're in a hospital to help you find the person. And then, of course, the doctor's input is extremely important in that respect. If the ball question is if the patient has no surrogate available and nobody to consent, as is unfortunately frequently the case, we see at Parkland a lot with homeless people. We don't know who their kindred are. They won't tell you, and it's very difficult to find out. In that situation, the doctor makes some decisions, and at Parkland, for example, if the doctor has any question about that, they can refer that to the ethics committee and ask for a consult from them, and that can be arranged very quickly in an emergency. So can you think of anything else, Ray, about that, how doctors deal with that?
I can take that one. Hey, Jack, it's Gil Salazar. How are you, sir?
Hey, Gil, how are you?
Doing good. I was giving you a lot of props for all the years of kindness and advice and mentorship you gave me, and I'm just delighted to have you here. I was kind of on the chat, I was talking to the students about the true need for advanced directives in our living will so that clinicians like myself and Dr. Fowler at 3 o'clock in the morning don't have to be scrambling for kind of some guidance and assistance when taking care of a critically ill patient, because a lot of these decisions don't happen in the middle of the day when everybody's awake and everybody's got the phone on them. It always occurs at the worst times. So when we do have to make a really tough decision in the emergency department with somebody that has no next of kin, no surrogates or anything like that, I try to remember the following. The patient's dignity is the most important thing at that moment in their lives. And I'm going to look at them the way I would want to be treated at that moment. And the decision is not always about doing the most aggressive thing for the patient. Sometimes the most dignifying thing you can do as a physician is allow them, for example, to die comfortably, for example. So I just advocate for all of our students out there, kind of never too early to begin to think about these things, especially if you have older parents, grandparents, etc. Let's get some advanced directives.
Yeah, I echo that, Gil. In Texas, using us as an example again of maybe how not to do it, we actually have a statute that refers to out-of-hospital DNR orders, which complicates things, obviously, because DNRs are normally in the hospital. So there's a mixing of terms there that shows you the legislature's wisdom in our state. But it also is a complicated procedure as well. And what Dr. Salazar is saying is certainly true. The doctor has tremendous input into the decision as to whether or not or in what manner to resuscitate. Not every patient it's not medically indicated to resuscitate them, as Dr. Salazar alluded to. I agree with that completely.
All right, so next question we have is, when does implied consent become or is considered forced consent in like the eyes of the law? And when does the patient do not have the capacity to consent? But sorry, words are hard.
I'm not sure I followed that.
Sorry. When is implied consent? When does implied consent turn into forced consent, or when does forced consent?
Well, there's no such thing as forced consent.
Okay.
Implied consent is consent that is supplied by operation of law when the patient is unable to consent. In our EMS statute, for example, we use the language is unable to consent or is unable to communicate by reason of disease or illness, and is suffering from what reasonably appears to be a life-threatening condition. That's a statutory definition in a pre-hospital context. A similar thing exists in hospitals, as I previously explained. So the implied consent doctrine would apply only to the extent that the patient is unable to speak or communicate with the doctors themselves. Once they are returned to a sapient state, as Dr. Posner and Plum would say, once that continuum starts to swing to the area of cognition and full understanding of what's going on, then implied consent would be concluded, and you would treat the patient as you would any other patient, which is you have to have their consent for everything you do.
Gotcha. Okay.
Did I answer that?
Yes.
Yeah, let me interject there. But now, Jack, you're on call for our EMS system, and let's say it's old Aunt Minnie and she's just really sick, and her husband calls 911, and we get out there to her house, and she is awake, alert, she has capacity, but she's really sick, and we know that we can help her, but she just doesn't want to go. But you can't force the consent on her, but you may get the judge out of bed to get something called an order of protective custody. Do you want to talk about that?
Well, yes. I don't want to sound like we're tooting our own horn here, but in, I guess it was 1979, when I started teaching with Dr. Petty, Dr. Anderson raised that exact question that you just raised, Ray. What happens in the field when paramedics have a patient with a viable prognosis with treatment and the patient's ability to consent is in question? And the way that that presents itself is multifaceted, but let me give you some examples. If the patient, for example, I'm just using Aunt Minnie as an example, has a fulminant urinary tract infection, that may affect their cognition significantly. They may present in a delusional state or hallucinating or anything in between, and their ability to understand what's being said is very much an issue. So yours truly, I wrote the Texas EMS statute that created emergency medical services in Texas, and one section of it enables EMS providers to seek court intervention to obtain court orders to treat those patients. Again, not trying to toot my own horn, we now have somewhere in the neighborhood of 2,000 cases in which we have had favorable outcomes. We have never had any adverse litigation. We have never had any adverse outcomes. And in every case that I'm aware of, when the patient became more oriented as to what was going on, typically as a result of drugs or alcohol, but not always, they're very appreciative of the fact that somebody went to all that trouble to get them treatment. And again, going back to my dear friend, Dr. Anderson, your position in the courtroom in that situation is, we're glad that you're alive to complain about. You all are probably.
You mean people people can sue you for wrongful death? You know, the family sues because a physician did something wrong, but they generally don't sue well for wrongful life. Is that what you're saying? Yes.
Again, showing my age, Fowler will remember this. There was a famous ad. It was a dog food commercial, and the dogs would kind of do their heads like this, when something strange was happening about their dog food. That's exactly how jurors look at the plaintiff who comes in, and please forgive the language. The plaintiff's theory of the case is, you saved my life, you dirty bastard. And the jurors go, what? You're complaining that they saved your life and you want us to award you damages because they, stuck you in the arm with a needle and saved your life? Those are fairly short deliberations, and they generally don't do well. But the point is that if you, to use Anderson's example, you can be sued if you do either thing. You can be sued if you treat them or if you don't treat them. We're going to be on the side of the angels in our system, and Dr. Fowler is the chief architect of that because he's chief of the service. We believe in trying to save lives. That's our job, and that's what we try to do.
Jack, how many times in 40 plus years have you gotten the judge out of bed to say, look, we need to bring this patient to the hospital against their will?
Well, I think the last count is 1,563, I believe.
Amazing.
And what's wonderful about that is these judges get up in the middle of the night and hear it. They hear it, and they issue orders, which speaks very well for them and for their dedication to the public. And I'm deeply appreciative for that. And I'm also appreciative, it wouldn't be possible without doctors like Dr. Salazar, Dr. Fowler, and our faculty at the school, who are very supportive of that program and very supportive of my efforts. And I should say, I have a son who practices with me who's also now heavily involved in that program as well.
Rachel?
I think we should move on to the next part. We only have 30 minutes to cover the rest of the presentation. Quick little thing, Dr. Fowler, can you put your cursor to like the edge of the screen? We can see it moving all over the place. But Mr. Ayres, can you continue?
Sure. The sixth slide is about patient consent, and actually we pretty much discussed this already. It's stuff that we've already talked about. The difference between Dr. Fowler's comment, which is absolutely correct, the difference between capacity on the one hand and competency on the other. One's a legal question, one's a medical question. Let's go to the next one. This was my effort to sort of tell you as budding physicians when legal representation would be of benefit to you. And I tried to give you some examples because of these. I have seen many young doctors get in serious trouble by trying to save money by not hiring a lawyer to help them at critical phases in their life. For example, when you're making the decision to get married, you might think, well, why do I need a lawyer when I'm trying to decide whether to get married or not? Well, if you happen to be the heir to a $200 million estate, you may want to talk to a lawyer about a prenuptial agreement to be sure that if the marriage doesn't work, because more fail than don't fail now, that your fortune is not tied up in litigation for years because you don't have such an agreement. That's just a small example. The next one is business organizations. Many young doctors will go into a facility and they will sign whatever form documents the leasing agent for the hospital gives them, which frequently is extremely high rent. Sometimes some of them have escalator clauses in there based on your billings. You should not sign any documents, practice agreements, leases, or any other binding legal document without consulting your own attorney. And if you think you're saving money by doing that, I promise you that you're going to cost yourself money in the long run because you're going to end up in litigation about it, or you're going to end up in a bad financial position. Another thing you need a lawyer for is estate planning. We have an expression in Texas that's very interesting way we express ourselves down here. We say, where there's a will, there's a way, but where there ain't no will, there ain't no way. And if you die intestate without a will, then you have to go through a long court proceeding, which costs a lot of money, which could be avoided by simply having a will. And if you have children, it's even more important because you can designate who you want to be the conservator of your child should you and or your spouse pass away. So those are very important things. The other thing I mentioned to the left there was tax lawyers. A lot of people go to CPAs thinking that they are lawyers about the tax laws, and they are not. They are knowledgeable of the tax regulations, but they don't necessarily know what's constitutional and what isn't, or what the correct terms are. So bear in mind when you're talking to your CPA, you may also need a tax lawyer. I'm not promoting hiring lawyers. I'm just telling you that if you don't do that, you're taking a big chance with your own financial security. Another question that Rachel raised in previous discussions, and I wanted to mention briefly, is how do you find the right lawyer and how do you avoid the wrong lawyer? Generally speaking, if you see lawyers, this is my personal opinion, if you see lawyers that have a practice of a certain type that they advertise their services to the public, you might want to consider looking at somebody that doesn't need to advertise to support themselves. That would be some indication of where they are in terms of their ability. There are rating services. One is called Martindale Hubble, which is a legal reference directory for all attorneys in the United States, and it has two standards of practice. One is professional competence and one is ethical standards. And an AV rating means that you meet the very highest ethical standards and your very high standards of professional practice. AV. There's another thing called AVO, AVVO, which has a similar thing in which they rate the competence of lawyers. The internet will give you an enormous amount of information where you can check out the credentials of any lawyer that you want to hire. See where they went to the law school. See if they wrote for the Law Review. See what their academic background was. In my case, I'm board certified in Texas in 3 areas. That's not necessarily real common, but that tells you that that person has gotten the recommendations from judges that they appear in front of and has taken a very detailed examination to demonstrate their competence. Many people refer to themselves as experts, and in fact, they're not. You can always talk to friends about lawyers, but the problem that you have is when you do that, you may be getting the friend's golfing buddy who may not be the best doctor for you. I generally try to avoid, in my own case, I try to avoid dealing with people like that. I try to make my own decisions based on my own judgment. But certainly you can consult with friends. That's very common in divorces. where, you know, you'll talk to another doctor who just went through a divorce, and that doesn't mean that that's the right lawyer for you. That means that that was the lawyer that that doctor had, and it was whatever it was in that case. But don't get too far over your head. I would encourage you, if you can, to make contact with a lawyer that has a general breadth of practice who can kind of be the captain of your ship, because they can usually do a better job of finding the lawyer you need in a specific case than you can. That's just my personal opinion. That's worth exactly what it cost you today. Okay, let's go on to the next one. Okay, this is something I shouldn't have to talk about, but because I see it happen over and over again, I'm going to mention it. Your relationship with your patient is fiduciary. That means that a breach of fiduciary duty will subject you to liability. Going into business with your patient, not a good idea. Going into business with the patient's relatives, not a good idea. Even worse idea, to have an intimate or sexual relationship with the patient or the patient's family. These things are simply not acceptable, and they will get you in trouble. And you'll get in trouble with your medical staff privileges. You'll get in trouble with the state board. You get in trouble with everybody. Basic reason for that is your judgment has to be solely for the patient. You can't be thinking about who you're sleeping with when you're trying to concern yourself with what's the best thing for the patient. So stay away from that. Do not engage in that sort of thing, because you're risking your career when you do. Let's go to the next one. Another thing that I wish I didn't have to talk about that I do, and I said it, I think, pretty well, if I did say so myself, in regard to the slide. Alcoholism is very common in the medical profession. It's also very common in the legal profession. It is a disease, and if it's untreated, it will kill you. Generally, it'll kill your liver, but it may kill you by running into a light pole when you're drunk. It will damage your practice, and ultimately it will destroy your practice, and it will destroy your family too. I said in bold letters, their recognition that you have a problem and an illness is not weakness. It's actually the greatest form of strength. And treatment is not weakness. Treatment is using your head. When you have an illness and you have a disease, you try to treat it. We have a lot of programs now in our medical school for practitioners who have problems with alcohol. And that enables them to get treatment in complete confidence, in complete privacy. And if we've been involved in some way in some activity that they sometimes show up when they're still intoxicated, treat patients or something along those lines, we generally can deal with that in a non-punitive way. The other thing I want to discuss with you very briefly is the use and abuse of drugs and drug diversion. And this is less frequent than alcoholism, but it happens, and it is not just limited to anesthesiologists. Some people seem to think that anesthesiologists are more likely to engage in drug diversion because they're handling all these drugs and can drop these things in their pockets and so forth. Again, drug addiction is a disease, and you need treatment for that. The difference is that drug diversion is almost always a crime. If you're getting drugs from some third party, let's call it what it is, you're dealing with a criminal. You're dealing with a drug dealer, and drug dealers don't have the highest standards of ethics and propriety in their dealings with you. And so if things don't work out well for them, they just put a bullet in your brain. They didn't read about you, and they didn't know you were special. They're just interested in what kind of money you have to fund your drug habit. So the long-term effects of drugs are disastrous for doctors. And again, you've got to if you have that problem, go to a friend, get into a treatment program where you can have your privacy, and you'll have to take a little while off from your practice, but at least you'll be in a position where you can function, because without it, you're on a dead end. I would call it a suicide mission. Let's go to the next one. I mention this just so you know it. When I say help is available, communications that you give drug counselors or alcoholism counselors or psychiatrists or psychologists or licensed professional counselors are privileged in almost every state. They cannot be revealed by the therapist without your consent. I have a friend who's a surgeon who's wound pretty tight sometimes, And I was talking to him about this, that I was going to do this thing. And he said, you ought to use me as an example. And I said, well, what do you mean? He said, I go to see a therapist every week. I said, why do you do that? He said, I work out 3 times a week. I go to a surgeon. I go to a therapist once a week. I'm interested in keeping my body sound, and I'm interested in keeping my mind sound. And so I can talk to them about things that bother me, if it's things in my marriage, if it's things with my children, I can get all that stuff. And he said, I feel like a new man every time I leave the therapist's office. Best money I've ever spent. My experience with doctors is that they generally are resistant to that sort of therapy. They don't think they need it. They think they know more about it than the psychiatrist does. Always they think that they know more about it than the psychiatrist does, and they may be right, but that's beside the point. And some of you may not know this, psychiatrists in many cases are required by medical staff bylaws and by the standards of their subspecialties to be in therapy, at least on a quarterly basis, to be sure that everything is going well for them mentally, because they're exposed to so much mental illness and so much aberrant thought. That's just an example. But my surgeon friend did me a favor by telling me that, because if you want to, think of it just like you would think about working out. If you like to run or you do something else to keep your body in shape, what do you do to keep your mind in shape? What do you do to help you solve problems that you don't know? Because one of the big problems with doctors and lawyers too, and cops and a lot of other people, is that we think we can solve it ourselves. We think we can handle it ourselves. I can't tell you how many drug addicts I've known with doctors who told me over and over again they thought they could handle it. They thought cocaine wasn't going to get them, or fentanyl wasn't going to get them, because they could handle it, and they end up in a crisis. I am extremely conscious of the last thing. If we can go to the next one. This is just quick, and this is an editorial by me in large part because I believe in it so much. Many doctors approach the law from a standpoint of fear and anxiety about being sued. So I'm going to make you all junior lawyers today. If you all hold up your right hand and swear that you want to be a junior lawyer, I'm going to tell you how to do that. And the question that your client is going to ask you, can I be sued if? Fill in the blanks. My dog wee-wees on the neighbor's plant. Yes, you can be sued for that. I back into my neighbor's automobile. Yes, you can be sued for that, and so forth. You can be sued for anything. That's not the question. The question is that suit going to be viable? And in most instances, it's not. Now, why is that important? When we're talking about patient encounters, the best way to avoid claims by patients or the next of kin if the patient dies is to act in a competent manner and maintain your competence by continuing medical education. You will be shocked to see how many physicians fall behind on medical staff requirements for continuing medical education. When I audit those records, I find it almost every time that the doctors do it and nobody catches it and nobody requires them to make it up. And that's a gravy train for the plaintiff's lawyer, because the plaintiff's lawyer talks out that the doctor's lying to his own medical staff about his medical competence. He's not getting the required training. It also sets the stage for the doctor being viewed as arrogant and above requirements of standards, which makes the plaintiff's job a lot easier. This is the more important thing. And it's a hard thing to verbalize, but if you'll listen to me and pay attention, you might learn something. In my experience, over and over again, I have seen this in many cases. Let's just take a hospital experience of a patient. I'm familiar with the ER, if that's okay with you. Let's just assume it's an ER admission. Let's say that you're a resident doctor. You're in your second year of training, so you got your feet under you, kind of clinically, you know what's going on. And you've got 4 patients that you have to see. Right? You with me? You've got 4 charts. Maybe if you're sufficiently proud of yourself, you have a scribe, because it's too much for you to have to write anything in the chart. You know, you need to have somebody do that for you, right? Which I think is not a good idea, but go ahead if you want to. Okay, so when you walk in to talk to that patient, how do you approach them? They're lying down flat, looking straight up at the ceiling, usually. Sometimes their head's elevated if they've got a good nurse, right? How do you approach that patient? Here's an idea. How about introduce yourself, talk to them? How about pull up a stool and sit down and talk to them and look them in the eye and listen to what they say? One of my professors in medical school told me, Jack, you will never make it as a doctor until you listen to your patients. If you listen and you ask enough questions, they will tell you what's wrong with them. But you've got to listen. If you don't listen to the patient, if you come in and you just sort of make a sashay through there, well, Miss Smith, we're going to order this and we're going to order that and we'll get back to you. And then at the end of the day, you can't even remember what patients you saw. You don't have any relationship with them at all. They're just numbers to you. That shows. I gave this example because it came from a doctor that meant a lot to me. And here's my scenario. Here's the patient. Here's what the patient said after talking about Dr. Smith, who was her doctor, or his doctor. I could see that Dr. Smith was very, very, very busy. But even with everything else I know he had to do, he made me feel like he had nothing else to do but to talk to me. He sat down and looked me in the eye. He cared about what I said. He really listened to me. He was concerned about me. What a doctor he was. I trust him and I like him. He really cares about me. What does that cost you? What does that kind of relationship with every patient you see cost you? Nothing. And I got another clue for you. It's good medicine. I'll give you an example. I'm not going to identify who the doctor was, but I was in Parkland some years back, and I don't know how I got assigned the job, but I was supposed to look in on a patient that was in the booth in medicine, which we say in our parlance means that they're seriously ill, but they're not in an intensive care unit yet. And this patient was about an 80-year-old lady, 70, 80 years old, cachectic, obviously a COPD person. She was breathing about 35 times a minute. Her eyes were about the size of silver dollars. She was scared to death. She was by herself. And I walked in, and the resident was sitting with her back turned to the patient, calculating dosages on her computer. She never saw me walk into the room. She was completely unaware of the patient. I walked in, pulled up a stool, took the lady's hand, and asked her, told her who I was and that we were going to take good care of her. She was going to be all right. I wanted her to slow her breathing down. Let's talk about how things are going. I know this is kind of frightening to you. Why don't you tell me how you feel? And let's see what we can do to address this so you'll feel better. And I'm watching the monitor on this lady, and I watch her heart rate go down from 120 to 80. And she starts squeezing my hand, and she says, I think I'm going to die. I'm afraid I'm going to die. And I said, not permitted. Don't permit anybody to die in here. You cannot die. That's prohibited. I see a smile on her face. And when I left the room, that resident never looked up from calculating the dosage for their patient. Now, Dr. Fowler or somebody like him probably had some sharp words for that resident when I reported that. It wasn't to criticize the resident, it was to try to save patients' lives. When I'm in the back of an ambulance with somebody that's gunshot wound, maybe some gang banger, whatever else, they're scared to death. They're afraid they're going to die. What does it cost me to, after I've done what I need to do for them therapeutically, to hold their hand on the way to the hospital, to tell them they're going to be okay? What does that cost me? That communicates that you care about your patient. And so many doctors think that that's a sign of weakness or a sign of trouble, and it's not. But it requires you to be willing to make yourself vulnerable, not to present yourself as infallible or omniscient or omnipotent or whatever else you think you are, but as a human being that shares your humanity with another person. They can give you no greater honor than to trust you with their life. Are you worth it? Do you justify that trust? And if you do, then try to put them first and try to think of them first rather than yourself, rather than what you're going to have for dinner tonight or anything else. Focus on them. And I think if you do that, you'll find that that patient will be the least likely to ever sue you. I'll tell you one other quick war story. Years ago, I was on a committee at Parkland where we looked at patients that had come to us from other facilities. Ray and I say chicken switch general, so that we don't identify the hospital that they came from. And, you know, people that didn't have diabetes diagnosed for 15 years with high blood levels. Nobody read the lab results. Nobody looked. And the patient comes in and they're damn near dead when we get them. And so we were trying to create a situation where they could understand what had happened to them. And then inevitably, when it would come up, and he would say, well, you know, Dr. Welby, you know, was managing this, and, you know, one way that we could have handled this was if you had your diagnosis on your diabetes, that would have probably helped, you know. And they'd say, oh, well, you know, Dr. Welby took care of us when we were sick and we didn't have any money. He cared about us. He came out to the house to see us one time when somebody was sick. They're not ever going to sue Dr. Welby. And they're not going to sue you either if they look at you as a person and you do your best. And if you make a mistake, here's another thrill. Be honest about it. Don't try to cover it up. Don't try to hide it. Don't lie about it. Tell the truth. And I think you'll find that I can always defend the truth in court. And I can't defend anything but the truth, and I won't. So that's my take on all this. I think that, as we say in church, Ray, that concludes the reading of the Holy Word for today. That's it. I think I've lost you. Can you hear me? No.
Can hear you.
Or not.
Oh, so
Okay,
sorry.
good.
Yeah, there we go. I hustled through those last because you covered all those
Ray?
points, Jay.
Ray, was that a transient attack or what happened there?
Jack, that was a tremendous discussion, and it's based upon your long experience. But it's based upon another thing, Jack, is that you're a very civil, decent man, and you treat people. I'm not selling you anything. I'm just telling it because I know you're from Chicken Switch. You treat people the way you want to be treated. And that's the message that we're taking home tonight, is that the safe part, the accurate part, but the humane part of medicine is to treat folks like you treat yourself and your own family. So thank you for that. Rachel, you got a couple of questions for Jack to round off the evening?
I do. We'll just do a couple more questions and then we'll talk about the assessment. So going back to your therapy point, love therapy, how does therapy work with patient confidentiality? Could a physician talk about a patient to a therapist?
Oh, that's a good question. And the answer is there's case law on that they can, because the communication is privileged. You can't be forced to reveal that communication because your communications with your patients, yourself as a physician, are privileged. But when you reveal those things to a therapist, that's covered by the same privilege that you have. But to be on the safe side, you might want to refer to that as patient one or Joe Smith or some pseudonym, so that you protect the patient's privacy even in that context. Does that make sense?
Yes, gotcha.
Okay.
Better be on the safer side. So a student asks, going back to the point of being disabled beyond a reasonable expectation of recovery point, how do you measure that? Is it something by law that measures it? Is it something per hospital, per clinic?
I always think that is a medical question that has to be made by the doctors at the bedside. And what I advise doctors to do in that situation from a legal perspective is when they think that a patient's reached that point, I encourage them to get at least one consult and maybe two to be sure that other doctors agree with that. What you don't want to do is encourage a patient to not be resuscitated or make some end-of-life decision when, in fact, they may have a viable prognosis or there might be a reasonable disagreement. And I think that when you document that in the chart by consult, that shows your good faith. And that's the sort of thing juries look for. Was the doctor reasonable in what they did? And they were. They weren't just relying on their own judgment. They were also willing to go to someone else. That implies that the doctor supports their diagnosis with other medical opinions. Does that answer the question?
That absolutely answers the question. So A student asks, so say if a patient says that there's conduct issues with the physician, what is the process to report physicians to the medical board, or do they just go straight to, suing them?
Okay, it depends on where it happens and who the person complaining is. If a doctor's conduct in the hospital is objectionable from the standpoint of another healthcare provider, like I remember when I remember being in a room with a very famous surgeon. I won't mention his name or his specialty, who threw I think it was a lap pad at a circulating nurse because she had done something that was irritating to him. There is a procedure in the hospital manual for nursing whereby nurses can make a complaint in what I would call in their chain of command through the nursing division that will then be brought to the attention of the medical staff and or hospital administration. So you have to be familiar with the policies in that hospital for dealing with that. But I can tell you that those in good hospitals, those are taken seriously. And the doctors that do that are repeat offenders. And so they don't last long. When you do that, you will find that sooner or later they're going to suggest that you take your privileges elsewhere. If the situation is one in which the complaint is being made about a physician, or it could be a nurse practitioner or a paramedic or anybody else, it depends on the nature of the complaint and where it is. For example, if it concerns a medical subject involving a physician, there is a procedure at every state regulatory agency that I know of, certainly in Texas, whereby you can make a complaint about a doctor directly to the Texas Medical Board, and they will investigate it. And in the past, just to give you an aside, in the past, when we started off, the Texas Medical Board was entirely made up of physicians. Mm-hmm. Now physicians are majority on the medical board. Now laymen are in the majority, and some of the doctors that get on there can be very hard on other doctors. So it is no longer a place you go to hide. It's a place where there's real investigation involved. The same is true for the medical staff. I tell people when they have some concern that they come to me with about something that happened in a hospital, I think that's a real good place to make a complaint. Make a complaint to the chief of service of the medical staff. If somebody says that, because I guess technically Dr. Fowler's my boss because he's chief of my service, I slapped the patient or something, Dr. Fowler wants to know about that. And it needs to be documented, and it needs to be investigated. I don't mean that you jump to conclusions or sustain the complaint or anything, but it needs to be evaluated. And good quality assurance is good medicine. The physician who's behaving in a competent and reasonable way has nothing to be concerned about with quality assurance. And the same thing is true for patients. And the other thing that I do sometimes, when a person is angry about the outcome of a medical procedure, or I get a lot of this. I mean, people call me up, judges and all these other people call me up, raising Cain about certain things. I always suggest that they make a complaint to the medical staff of the hospital first, and or that they make a complaint to the Texas Medical Board. Why do I do that? Because that heads off a lot of lawsuits. Because once that's investigated, the investigator will usually contact them, will talk to them about the case, will explain the standards of practice, and will give them an education that may mean that they don't go forward with litigation. And if they do go forward with litigation, then that's a different issue, and that requires the intervention of a lawyer, obviously. But at the preliminary stage, I don't think it does. And Ray Fowler, my friend, made a profound statement. I should have said it myself. I wish I had. In this connection, the best standard you can have is, have I done everything I could have done for this patient? Have I done everything I should have done for this patient? And the last question is the most important. Have I done everything for this patient that I would have wanted to be done if that was a member of my own family? And you may think that you don't deserve it if you're falling down intoxicated because you misbehaved, but you would never think that about your mother, or you would never think that about your father. And so that's an insurance policy that if you can say that with an open mind and a faithful heart, that I've done everything I reasonably could do and I would want done if it was a member of my own family, you're probably not ever going to need to see me, which will be good news for you. Nobody likes to trial lawyer. Worse than a neurosurgeon.
Well, thank you, Mr. Ayres. I think that's all the questions I have for tonight. It was a wonderful presentation. Dr. Fowler, would you have any other additional words you'd like to say?
You know, Jack Ayres, what an amazing guy. I've known you much of my adult life, and I've been with you through hundreds and hundreds of cases. You helped start the EMS system from a statutory standpoint in the state. You've published chapters in our legal textbook, including last year. You've contributed so much to medicine, so much to law, to public safety. You're one of the finest humanitarians, and I think that Rachel and Reagan and I are going to be forced to take you to lunch one day just to say thanks. So I want everybody to put into chat. Everybody put in chat, and Jack, I hope you can look at chat. Say thank you, Mr. Ayres, for what a wonderful presentation. Jack, I want you to know that. I want you to know something. Just take this home with you. Is that ultimately about 5,000, we had over 600 people listening to you tonight. Ultimately about 5,000 people will see it. All of these future medical practitioners, each one of them will see about 100,000 patients in their lifetime. 5,000 times 100,000 is 500 million. Jack Ayres, tonight, you will have touched 500 million lives of people that you will never know. And we're just so grateful.
That's very rewarding and terrifying at the same time.
All right. So
you can go to the slide, please.
Thank you so much, Rachel.
Thank you for joining us. So this is the Quest-based information for assessment number 37. You do not need a Quest-based account. All you have to do is put in the PIN with the dashes in that little space that says find assessment. It'll take you to our assessment. You input the password Ayres. There's no caps or spaces in the password, and you have approximately a week to pass and get credit for this session. Remember to get your certificate. All right, thank you so much.
So thank you, everybody, for coming. We wish you well. And on behalf of the whole virtual shadowing team and Mr. Ayres, we say thank you and have a great evening. Good night.